So this is what we're going to do today. You see the website of the project. There are 2 postdocs and 2 PhD students involved together with me on the business corporation as a political actor. The project has been running since a year now, and we have 4 more years to go. Next slide. How should I do that? Yes. The presentation comes in 3 parts. I'll first talk about 2 papers that reveal the analytical stuff. So first, some preliminaries on what is a corporation, what is corporate power, and how to theorize the normative question about the power of business corporations. So in this part, I want to give some tools, but I won't be arguing anything myself normatively. So as a political philosopher, political philosophers are often used to normatively argue a position in the literature, but they also do analytical work purely by outlining and clarifying positions. And this is what the first part will be doing. With all of that as a background, I'll go to the second part where I will take a normative position on the responsibilities of business corporations. That is in 2 papers, and we'll talk more about that later. And then the final part is the more practical part. So where we want to see how we can hold business corporations to account in practice. There's one other paper I wrote about this. This is giving the utopia of Bennett and Claassen, the utopian solution about how to deal with business corporations, admittedly provocative. And then there's a more reconstructive diagnostic paper about how other people are dealing with the practical problem of the business corporation. And this is the text you've read for today. So I won't be saying much about that. So let's get started with the analytical frameworks. What are we talking about? I'm going to very briefly, because I know you come from a very large variety of backgrounds, and the corporation is, thinking about corporations is an interdisciplinary endeavor. So I'm going to briefly try to put all of us on the same page. I'm here talking about corporations, that is legal persons that have the ability to contract and own property as if they were a natural person, right? These legal persons have a centralized management over the property, and so they have a board or a government, and they have a right to make laws, bylaws, as long as these are in conformity with the laws of the land, which are imposed on their members, if there are any members. Please, don't forget that. We'll talk about members later. So there's an internal jurisdiction that the centralized management can impose over the corporation. This is a minimal understanding, as it's, to the best of my knowledge, evolved in the Middle Ages and was put to use to a variety of structures. So in the Middle Ages, legal personhood was often, not always, but often granted by the state or a king through a charter of incorporation for a specific public purpose. Nowadays, however, anyone can start a corporation. Now, this conception is more general than the specific conception of the business corporation. So today I'll often just say corporation when I mean business corporation, but actually there are more incorporated groups than just business corporations. And here you see a brief structure of how we could table all of them. So of course we have collective actors that are non-incorporated in the market, but also in the non-market sphere. And then we have incorporated groups that have been granted legal personhood through law. And here in the market, we mainly think of business corporations. In the non-profit sphere, we can think of foundations and associations. And then there's the state, which is itself, I would say, a corporation, but more about that in a moment. Now, what distinguishes the business corporation from other corporations? Corporate lawyers will say 5 features. I'm not going to discuss them, but I just list them. Asset lock-in, entity shielding, limited liability for shareholders, then shareholder control. The shareholders can elect the board, and the ability to transfer your shares to others. Together, this structure makes it possible for the corporation to act separately from its shareholders, from its main investors, while at the same time being a structure that is giving incentives to investors to invest in corporations, because there are, especially the third feature, only limitedly liable for the risks that the corporation runs. We can talk more about this, but a good explanation of this slide would have taken 10 minutes, so I'm not going to do that. Now, this structure is highly conducive to the pooling of capital. So the corporates, the structure of business corporations, as it's evolved since the 17th century, with the trading companies of the Netherlands and the East India's company in the UK is highly conducive to the pooling of capital. So you get concentrations of capital, and that means concentrations of power. And of course, empirical work in the political sciences and international relations, etc., studies the different manifestations of that. This power structure is meant to serve the interests mainly of the suppliers of capital, shareholders. Hence, the business corporation is often associated with its shareholders. That is, of course, a big statement. Here, it's just more or less a factual statement, right? So we'll get into the controversy later on. This gives rise to different types of power. This is one classification. There are others, of course. So power over competitors and consumers. This is the market power that economists study when they study oligopolistic and monopolistic market structures. But also what we could call firm power, the power of the employer over the employee in a firm context. In political philosophy, there has been quite a lot written about this. For example, Elizabeth Anderson's book on private government. And then there's political power in the sense that corporations, the large ones, often have some direct power over political institutions through their lobbying, but also structurally, so without doing anything by virtue of their position in the economy. There's also more indirectly corporations rivaling political power, political institutions in the sense of providing goods and services that would, in other contexts, be provided by the state. This is especially important, of course, in a globalized context. Now, with these preliminary matters out of the way, let me proceed to the first paper I want to say a bit about. So the first paper tries to shed some light on the different trade-offs in dealing with corporate power, and to do so in a way in which economic and political norms can be put into dialogue with each other. So it's forthcoming, and I've just finished the proof, so it should be online first in a couple of weeks, I think. It's called the Corporate Power Trilemma. So Michael Bennett and I, my former postdoc, we tried to find a way to bring economic and political considerations into dialogue with each other, which often doesn't happen, right? So there's an economic story about different types of efficiency, which you have on the one hand, and then there are more political frameworks on the other hand. We try to bring them together. How do we do this? Well, by creating a trilemma, or at least we discovered a trilemma, you might say, or you might disagree with that, of course. That's part of the academic conversation, in which we say that, well, we have basically three options in thinking about corporate power: accepting it, making it accountable, or reducing it. And in my field, at least in the political philosophy, most of the attention is in making corporate power accountable. So there's no way of accepting it. That's often not something political philosophers want to say. But there's also very little attention in thinking about reducing corporate power. And the arguments are often very diffuse. We try to bring more clarity here by saying, well, these options have to be brought into contact with three different values: minimizing agency costs, maximizing economies of scale, and maintaining a power balance. And then if we do that, then we see that there's a trilemmic structure. All of that is much more clear graphically. This is a bit technical, so I just want to give you a flavor of this, but we could talk for 45 minutes about this alone, so we won't do that. So here you have the trilemma. So our analysis here is that if you start on the bottom right, you have powerful firms, so firms that have a certain measure of power over their employees, over other stakeholders, sometimes also over the state. Then this is a confluence of two facts: the fact that in this structure, agency costs are minimized and that economies of scale are maximized. So if you want to have a pool that is large, where you can profit from economies of scale, in which decision-making is relatively simple, decision-making and monitoring costs are low, then you give all the power to one group, the shareholders, to run the firm in their interest, and then you're in the bottom right corner. Another option, however, if we want to give up on some of the economies of scale, is to reduce the power of firms. And then you get into the left corner, where we have competitive firms. So you can think of antitrust policy, for example, as bringing powerful firms, reducing their power by enhancing the level of competitiveness with which they have to deal. That's one way of dealing with power. The other way is to say, well, let's accept economies of scale. So let's accept large corporations. but give up on agency costs. That is to say, give on minimizing agency costs and accept higher agency costs because of more heterogeneous groups that are going to do the decision making in the corporation together. And then you can get into the top of the screen. Both of these options create more of a power balance, but in a very different way. If you want to give up on the idea of a power balance between the firm on the one hand and its shareholders and stakeholders that are subject to firm power or market power on the other hand, then of course you're accepting corporate power as it is and you're back into the right corner. So this is one paper project in which we try to really bring into contact economic values of efficiency, economies of scale and agency costs, distinguishing between them, and the political concern with a power balance between different groups that are the objects of corporate power. Yeah, I think this is a good way of starting, but it leaves open why you would want to go, for example, towards more of a power balance. So more towards the left, either to the bottom or to the top. And for that, you need normative considerations. And this is where the rest of the presentation comes in. So second paper, which I published in Dutch, was a report for the Dutch government. And I hope to get an English version out, but that's still a bit difficult, is to think about how to legitimize the actions of corporations, how to legitimize the power that they exercise. And here my answer is, well, we need to think about the structure of representation that is going on. So corporations are abstract persons, they're persons in law. Who do they represent? This is really sort of the main question that has at least got me going in thinking about the normative considerations at play in the legitimation of corporate power. And I would propose there's a menu of 4 different normative theories that give different answers to that question. 3 of them are actually classical legal theories about corporate personhood. I won't go into the legal side today, but if you're interested in a bit more than of the legal side, we can talk about that in the Q&A. But I'm transforming these legal theories into sort of political, philosophical theories about the legitimacy of power, arguing that each of them has a different question to the answer, who do corporations represent? Now, this is taken from the Hobbes papers. I'll talk about Hobbes later. The simplest way to introduce the question about representation is by drawing this graph. So corporations have, in Hobbes' sense, an author, for example, a group of Christians, who can create a legal person. You see the legal person here, the abstract legal person on the left. This is the so-called fictional person, for example, a church. By giving authorization to act on behalf of that church to a specific group of actors, either one actor or a couple of them, so a pope or a set of bishops. If they act, the acts are attributed to the church. So the legal person is attributed the actions of the corporation. Although, of course, they're not, the legal person is not a person of flesh and blood. It's the actors acting on behalf of the corporation. All of that for a mandate, so for a purpose. And of course, the word purpose is important today in connection to the paper that you've read. A purpose which is a benefit, normally speaking, for the authors themselves, although not always, right? Now, this is a very general structure, which neatly shows us that there's always 3 types of persons in play when we think about corporate structures. And this is essential. I didn't understand it. When I got Political Philosophy 101, I didn't get away with this message. So I think everybody should get away with it. You can't do with just 2 persons, the authors and the actors. So there's the abstract person and there's the triad, which is important to understand the dynamic of the representative structure that is going on. And this structure can be sort of simply modified. Here you have the same scheme, but I put different names now at the places of the fictional person, which is now the state, the actor, so the sovereign in Hobbes' terms, or the government, cabinet of ministers, for example, and then the multitude of men, the citizens who have authorized the structure. So this is also how Hobbes starts. Thomas Hobbes in the Leviathan, in chapter 16, he gives us his theory of representation, starting from one person representing another, then moving to collective persons, both private and public, analogously. Finally, third time you get the same slide, the business corporation. So for the business corporation, On the left-hand side, on the top of your screen, this is the fictional person. There's the board of directors who act on behalf of the corporation and the management that is delegated day-to-day responsibilities for the corporations on the right-hand top. But who's the author? So I would say that for whom is this structure acting? So I would say there are at least 4 different answers that are each of them non-idiot. So I'm going to put 4 different answers, and I would hold that even though I have my favorite position here, that none of the 4 positions is idiotic or nonsensical. I'm going to leave that out of the picture. That's too complicated for now. So here's the 4 positions. So this is a graph which you maybe know from handbooks of business ethics or management and organization 101. You have the board of directors in the middle with representing the corporation. So here I've conflated the two circles from the previous screen that were on top, right? Then you have stakeholders. These are the yellow boxes, the shareholders and the state. These are all actors in the vicinity somehow of the corporation. Now, the first theory is the concession theory. So the concession theory says a corporation should be run in the interest of the state. The corporation is authorized by the state. It should be so corporations other than the state themselves. So first citizens authorize the state, then the state authorizes sub-state corporations, if you want, both non-profit and profit. So business corporations as these kinds of sub-state corporations are authorized by the state for a public interest that the state holds. I'm going to say more about this later, but this is the first option. The second option is the aggregate theory that arose at the second half of the 19th century, where shareholders are seen as the members, if you want, although technically I would hold they are not members of the corporation. And it should be run in the interest of shareholders. This has been unpopular for a while, and then it became popular again since the 1980s with the work of agency theory in economics, which is a variant, I would say, of aggregate theory. Then there's the real entity theory. That's a bit weird maybe, but this is a theory holding that the board of directors should represent the corporation itself. So that shouldn't represent any of the flesh and blood actors that you see outside of the center of this picture. No, it should represent whatever the purpose of the corporation itself is. And I think many of the purpose theorists that are also quoted in the paper for today would belong there. So they would say, it depends on the purpose. And the purpose is whatever is stated into the charter, right? So then indirectly, it depends on the founder or founders of the corporation. And the fourth one would be, the corporation should be run in the interest of all stakeholders. And let's include the shareholders here, right? So the fourth option, you should color the shareholder box yellow as well. All the stakeholders together have an interest in the corporation. They benefit or are harmed by the corporation, and they should be the ones for whom the corporation, who are represented by the board of directors. Now that can become very complex, of course, in reality. So that's the sort of normative analytical framework in thinking about the representation of the corporation. I haven't argued anything yet. So the third paper is a paper that I wrote on Hobbes and the business corporation, which has recently appeared in Polity, in which I first of all argue that business corporations are representative structures or artificial legal persons created by the state. The legal person is authorized by government/law, and the business corporation gets special legal powers from law, for example, the limited liability of shareholders. So all of this is already familiar from what I said earlier. And the representative question again is, for whom should these powers be exercised? Now, Hobbes, and this is, I mean, until the 19th century, there was only the concession theory, right? So in the 19th century, I should have mentioned this earlier maybe, the right for people to start a corporation was privatized, if you want. So it was opened up for everybody to start a corporation until the 19th century in most countries, at least in the West, so Europe and the United States, there was a necessity that the state would concede, would grant legal personhood, and would also check whether the corporation had a public purpose. Well, writing in the 17th century, then Hobbes must have been a concession theorist. That was the only theory around. He did have a special emphasis compared to other writers, however, in really stressing the fact that the corporation was something of a threat by definition to the state. So although states would give corporate rights to specific corporations, both non-profits, think of universities, guilds, towns in the Middle Ages, and later business corporations, they would, the threat was that they would become like worms in the entrails of a natural man. That's a famous phrase from the Leviathan. So they would become, sort of the embryonic framework of conspiracies against state power. So the sovereign power that should remain very strong in Hobbes's view to prevent us from backsliding into the state of nature would be threatened by business corporations. So all of that is not very surprising. What is surprisingly, I think, is that his text on a close analysis, which I give in the paper, shows that the caricature that is often made of concession theories today, in which they should only be, the corporation should only be there if there's a public purpose to be fulfilled, didn't even hold for his day. So I think his text shows that he allows for private purposes for the incorporators as well. So it talks about the companies of merchants, so the early trading companies in his days, and he allows them to strive for their private gain. But then he also makes remarks in which he shows that there's a public interest in the corporations. So I interpret him as showing that there's always a mixed benefit or a mixed interest in incorporation. He provides a proto-market failure argument when he criticizes the monopoly composition of the trading companies. So the trading companies had a monopoly both in selling goods and in buying them, so both overseas and in the home countries, and he criticizes this as not being conducive to the wealth of the Commonwealth. So he's making something that we would now call a market failure argument, which I think clearly shows that he sees the interest in wealth creation for corporations. And that, I think, does show the way forward to a modern day version of the concession theory, where wealth creation itself, although it is something that is from a private point of view, a private purpose, can also be seen as a public purpose. And this is an insight I'm capitalizing on in my fourth paper, and maybe that's the last one I'll discuss today, to have enough time for discussion. So to defend a theory, a normative theory of corporations, in which corporations have corporate boards have two fiduciary duties. So they're representing two structures, and the structure is irreducibly dual, I would hold. On the one hand, to the state and society as being represented by the state, and on the other hand, to the shareholders. So the first duty, I would say, of corporations is to create wealth, to create economic value, and then the state allows corporations to incorporate for that purpose. That duty, checking that duty, however, is delegated to shareholders as the proximate beneficiaries, as I would call it. So society as a whole profits from the idea, from the fact that there is a playing field of corporations that create wealth. On the other hand, society itself is not checking that, is not controlling that purpose, it's delegating that to shareholders because they have a direct interest in the financial well-being of the company. Now, some of my friends who are very critical of the role of shareholders say that I'm already conceding too much there, but that might be up for debate. I think it's important to recognize, and I can say more about that in the Q&A if you want. But then the second fiduciary duty, that should be, sorry for the wrong spelling, is not to dominate others in the economy while doing so. So creating wealth while not dominating others in the economy. The second part is the part of non-domination, which is familiar from, for example, Republican political philosophy. I'm not giving a specific theory of what it is to dominate others, but you can think of imposing certain negative externalities or exploiting certain parties in the economy as ways of dominating others. Now, this leads to a double fiduciary duty then. So the corporation must balance these two duties, and that's really different from, for example, the view that directors owe only fiduciary duties to shareholders, which is one-sided. Also different from those who would hold that directors owe a fiduciary duty to the corporation or the corporate purpose. That's another position. or that they owe a duty to multiple stakeholders. And here you see the different types of normative theory, which I mentioned earlier, all coming back. So what I'm trying to do is, I think, taking a position which has not been defended so far in the literature. There's a double fiduciary duty on the one hand towards shareholders, and the state has created corporate law, which has given shareholders mechanisms for the control of boards. There's a market for corporate control to the extent that corporations do not like it when their shares are being dumped. But there's also a duty towards the state, which is the duty not to dominate others in the economy. And for that, we need a mechanism to determine when business corporations dominate and to enforce compliance with the second duty. And I think the problem of all the debates about corporations today is the problem of a lack of mechanisms to enforce this second duty, the other half of the coin, so to speak. I've been talking for half an hour now, haven't I? I had already expected that. So we created a mechanism, a utopian mechanism, the corporate social audit, but I'm just skipping that, although it's great fun in the interest of time. Other people, however, are working on the same project, roughly speaking, I think, although maybe not with the same philosophical analysis that I've been giving. And these people organize around purpose as a general term, and around multi-capital and multi-value frameworks, especially when they link their views to accounting. And the paper that I've sent you today is the latest paper, which Tally Rector, my current postdoc, and I wrote this summer, in which you try to analyze what they are actually doing and trying to push them to become clearer about the exact objectives that they have, with a special interest in the question that if we are taking their claims seriously, aren't they then trying to transcend capitalism as we know it? So that's, yeah, on the one hand, part of the more practical papers that we've been writing, because it really looks at reform proposals that are being discussed today in the global academic sphere. On the other hand, it raises very fundamental questions about the nature of the capitalistic system that we have. Well, I hope this has been helpful in giving you an overview of the things I've been working on the last two and a half years. And I look forward to the discussion.
So Rutger, maybe you can stop the share screen, and I will take the cue. Ifat will be first.
Can you hear me like this? Or?
Rutger, can you hear Ifat?
Yes, I need to. Yes, I can hear you. Vaguely, but still.
I'll try to speak loudly. Is that better?
Oh, this is not so good. No.
So whoever speaks should come here, okay? I'll just wait.
Okay, I hope that's better now.
Still not really. Can you try to speak into the microphone?
Now? Is it better now?
Still pretty much the same.
Can you hear me now?
Well, it roughly remains. I can hear, so I'll try. If you speak clearly and slowly, then I'll probably hear the question.
I'll do my best to ask very slowly my questions. So I had two questions. One about the paper, and the second about the almost last slide you just presented. So I'll start with the slide one. So you presented your arguments about the dual fiduciary duties. Can you hear me?
Yes.
Okay, so I wanted to ask two questions about it. First, why is the fiduciary duty so important to you? Why is it important to you to use fiduciary law for the argument? And on that note, I wanted to ask you what you think regarding fiduciary duties of lawyers. So that's the closest example I could think of regarding your arguments, because there are many people who see lawyers as having a dual duty as well, towards their clients and also towards the states or the justice system. So I wondered, is it similar to your view, and sort of why is it important to phrase it as fiduciary law and not as something else? So that's one question. Was it slowly enough?
Yeah, that was good. Yeah, I'll answer it in a moment, or you want to first have my answer?
And the second question was about the arguments to the multi-capital theory.
Yeah.
I wonder, do you do them justice when you sort of present their argument as leading to a non-capital world? And can't you just say that you can do some multi-capital inside a corporation, but also stick to some financial arguments? So I'll give an example to make my question clearer. So I thought about a corporation, for example, that is for vegan food, okay? And it still wants to be a profitable corporation. It still wants to sell. It still wants, to do all the regular corporate law purposes. But it also has as a main non-financial purpose his commitment to vegan food. So let's say selling vegan food will become non-profitable, then the corporation will cease to exist, all right? But it still has a non-financial purpose as the main argument, and it's still it's not a non-profitable organization still.
That's the public benefit corporations, right?
Yeah,
That's exactly
yeah.
the same.
So I'm saying, doesn't that work with the multi-capital argument?
Okay, thanks. So first about I don't know if it would be possible for those who will ask a question next to speak into, so Hanoch, when we talked just before we started, right? You spoke directly into some sort of computer, and that was really clear. So
it was clear, but then people could,
oh,
now it can't.
okay. Okay.
Can I try now?
Yeah.
Is it working for you now?
Yeah, this is much better. Yes.
Can you hear me now?
Hello, maybe you should mute the main computer in your room and just leave your computer open. Maybe that would make it.
Is it better now? No, it's impossible.
No, but the speakers, the speakers are off. The speakers are off.
Okay. I'll just start answering, right? Okay. Okay. So as to the question about fiduciary duties, so I think corporations have three types of duties, right? They have duties towards the state to just obey the laws. So the state imposes regulations on all kinds of specific things, tax laws, product quality regulation, whatever, specific employee regulation. So there's duties to obey state regulation. Then there's duties out of contract. So the corporation, to fulfill its purposes, starts to make contracts with others and has duties to perform under the contracts that it makes. So fiduciary duties are sort of about the open-ended duties, well, in the economist's phrase, towards residual claimants, right? So to the extent that people do not have contractual rights, but still have some sort of right that the corporation listens to their interests. And in the corporate law standardly, so the fiduciary duties are either assigned to the corporation, so the board has a duty towards the corporation itself, but as we've seen, the corporation itself is an abstract fictional person, it doesn't exist, or it has duties, the corporate board has duties towards the shareholders. And then in business ethics, you'll find discussions about duties towards stakeholders, other stakeholder groups than shareholders, multi-fiduciary frameworks. So a lot of the discussion is in these terms, and the reason it is in these terms, I think, is because it's really about the element of trust. There's a vulnerability on the part of a beneficiary that a fiduciary must then honor, and that goes beyond the contractual and the, let's say, regulatory duties that a corporation has. And then the question is, do these duties exist, and then to which parties, right? So that's what I'm trying to, that's a playing field that I'm trying to work myself into by positing my view in opposition to the others that you've seen on the screen. I would be interested if you could send me something about lawyers. So I don't know whether they already have this sort of double fiduciary structure, but I would be interested in learning more about that. So maybe we can continue that conversation later today or at some other point over email. But if they already have what I proposed, then of course my argument is less original, but still important to know. The question about do I do justice to multi-capital people? So I was presenting this to a couple of people who do multi-capital work, and they said actually they don't that on a second thought they didn't want to be in the box of the radicals, as I put them, the two last objective functions where non-financial value maximization becomes an end in itself. They would be happy with keeping with constraint. How did I call it? Constrained financial capital maximization. So seeing financial capital as the primary game in town, but then increasing the level of constraints on financial capital. I think different people might react differently here, but this is one way of interpreting the vegan shop that you mentioned, right? So the constraint is pretty heavy, namely all the food sold must be vegan, and that's a difficult thing to do. Right, but then to the extent that all the food can be vegan, the corporate function is classical. It's to maximize financial value. Our argument, I think, is that if you move towards bringing non-financial forms of capital into the objective function, then this will lead to a trade-off in many cases with financial capital. And to the extent that you make the function skewed or biased more strongly towards non-financial capital, by increasing the beta or the gamma in the functions that you've seen, then we asymptotically, as it were, approach a point where non-financial capital itself becomes just positive, so almost zero, but slightly positive, right? And that's exactly what non-profits do. So my university, which is a non-profit corporation, like most universities, at least in the Netherlands, in Europe probably, tries to write black letters, so not get into the red letters, not get into a financially destructive position, but otherwise focuses on non-financial capitals, or at least that's what I always hope that our central universities are still trying to do. Yes, now I hear you. Yes.
Okay, perfect. So actually, so thank you very much for the conversation and for the paper, and extremely enjoy reading it. My question is related to the dual fiduciary question, but from a slightly different angle. So it's clear that fiduciary duty to shareholders, then it's clear how they can enforce it. I mean, they can sue the directors, they can elect the directors. We have hedge funds activism. We have all sorts of mechanisms to discipline them. It's noted as well. But when it comes to the second duty, then there is a big question, and you just touch upon it a little bit, but it's clear. I mean, obviously some people are skeptical and they say this duty, it's unenforceable, and since there is no way it can be enforced, right? And I'm not talking about compliance, because compliance is a different issue. I mean, compliance, that's the state can enforce, and that's a different story, and there are lawsuits that can be filed on camera credibilities, etc. I'm talking about the duty to do something beyond what the law requires, right? You think about stakeholders and their influence. So the major challenge would be how we will enforce that. How we will make sure that managers, considering their incentives, considering the fact that compensation is mostly linked to equity and the way they are elected. I mean, how in the current system, right? And you are not proposing moving to something radical from the current system, like providing stakeholders with the right to sue or something like that. So how, in the current system, this type of duty can be enforced? How we can confirm that it's not just a window dressing?
Yes, so that's an excellent question, which I've been thinking about for a long time. And there's only one way to answer it, which is to give you the slides that I haven't given you so far. Let me just do that then. Can you see that? Can you see the slides? So, I mean, the reason I'm going to, so this is just two slides, the fifth paper. So the unenforceability, I think, is a real problem. And I think you're right. It's not about compliance. So it's not about regulation, right? It's a mechanism to give a voice to all the interests that are not being covered by regulation. And I think the common view in the literature is that we should have some form of stakeholder representation here, if there's representation at all, right? So very often stakeholder theorists say, well, we should listen to stakeholders in dialogues, but there's no real representation being proposed. But some, of course, go further. They say we need to have representation of stakeholders, especially of workers, right? So think of workers' councils, maybe co-determination in the German system. That's the kind of representation that is often argued for. So what we're doing in this fifth paper that I'll talk about for 3 or 4 minutes now is to try to come up with a mechanism on a society-wide scale in which you could try to enforce this second duty. So the idea here is to have a public evaluation every 5 years, for example. In a cycle, could also be 4 or 6 years, of all major corporations in a specific society, in which you're going to rate them or rank them on the basis of some set of evaluation criteria that you come up with at the start of the cycle. They can reflect environmental, social, and governance issues, as investors often call them today, or a list of business and human rights, or other lists of corporate social responsibility that are made elsewhere. They could be determined by a citizen assembly. I think that would be a good idea, a citizen convention chosen by lot, or a government agency if you don't want to have any citizens involved. But somebody representing the state or the citizenry at large. And then the evaluation would lead to, in the end, a payment or a payout out of a fund. So you could imagine that all corporations would have to pay a fee for this evaluation system that they pay into a fund. And corporations which get a higher score would get a payment out of the system, and corporations that have a lower score, rank more lower on the ESG scale, would get a net penalty, if you want, or a net payment. So you would need to have a ranking, for example, in 5 tiers, A to E, where, for example, only 20% can get into tier A, 20% in tier B, C, D, E. And then the cycle basically is a cycle in which corporations are going to compete with each other on the criteria set by the evaluation. So on criteria of corporate social responsibility or ESG or whatever you want to use. You could also have a non-competitive setup, but I'll leave that out of the picture for now. And then you could have in the end the evaluation. So the evaluation could be done by citizen juries again, or by a parliamentary committee or expert committees, whatever you want. So this is a paper we've written. It's just one idea. I think it comes close to a couple of other ideas that I found in the meantime, in which you're not giving sort of a direct voice to different stakeholders, let's say, for example, workers, but in which you say, well, there's a general duty of corporations towards the state, not to dominate in the economy towards a variety of interests. Some of them are easily representable, like workers typically. Others are very hard to represent directly, like future generations or animals or whatever. And these interests must be ranked against each other, right? So different stakeholders can go in different directions. Their interests can go in different directions. So we need a way to prioritize and to make a final judgment which takes all of them into account. Again, beyond regulation. And this is a co-governing mechanism, basically. So it's not regulation, it's a co-governing mechanism next to the shareholder assembly. Corporations would be held to account for the more public aspects of their behavior, the large corporations only, I would say, by way of an evaluation in the corporate social audit scheme as I just presented it. So that's our utopian idea. Some people think it's a crazy idea, but at least as a thought experiment, it tries to give enforceability to the corporate, the second fiduciary duty, which is held towards state or society. Let me also mention one other paper, which I think is really interesting from the literature by Raylin and Biondi, which I can recommend. So they say corporations should also have a fiduciary duty towards society at large, but that duty should be represented by the shareholders, right? So you get a double fiduciary structure as well, but via the shareholders. So that would be the alternative. So shareholders now sometimes act as universal owners, as it is called, who have an interest in the well-being of the economy as a whole and represent society as a whole. So that is another way of bringing the sort of second part of the coin, the responsibility of corporations towards society at large into the picture, but then via the voice of shareholders. Well, we think it's better to have an independent line, right? An independent line between the citizenry and large corporations. If they have a very powerful position in the economy, as the large ones have, there should be a separate line opened. Doing that would also not just be good for enforceability, but also for, let's say, the trust in large corporations. Because now the dynamics in public opinion between corporations and the citizenry are often negative and based on incidents. Like there's a scandal, a pollution scandal, tax evasion scandal, whatever scandal. And there we go. It's not really productive. It's not really constructive. So this would be a sort of constructive way of opening up communication in deliberative democracy, if you want, between citizens and corporations. So that's my mini plea for the social audit as an example of giving enforceability. But there could be other ways. So people can come up with different creative ideas about how to increase enforceability on this second duty. And I would be happy to hear new ideas about this.
Okay, so thank you. I'll just read the follow-up question that's in the chat, and then we can continue to run, and then Asaf can ask afterwards. So the question is in the chat that is a follow-up on the two fiduciary duties again. Are they on an equal level, or what happens if the two conflict, and how do they decide on that matter? Okay.
I think this is in the end a political question. So I would say a priori both are important. I'm not going to say it's 70% one and 30% the other, right? They're both important and sort of one cannot be reduced to the other. I also, you could see non-domination as a threshold. So apparently, I would say it can't sort of sink below a certain level. But which part of the large edifice of norms that shelters behind the view, behind the concept non-domination, which norms should be more important than others, I think, for example, should be decided in such a corporate social audit process. So human rights norms, environmental norms, norms of tax evasion, privacy violations, what have you, and how that should be traded off against the creation of financial value or wealth. That is something that in the end, societies must, they must decide by, for example, strengthening or weakening the corporate social audit fund. So if you have a large fund, you can imagine that the premiums are high for the top ranked companies in the system, but the fines or the penalties are also high for those who rank at the bottom. If there's only a little money, not so much money being pooled in the corporate social audit fund, then of course it will be less of an important consideration to corporations compared to their duty to create wealth. So the citizenry can decide how strong corporations should take this second duty by creating a stronger or weaker enforcement mechanism for this second duty.
Ron, you can ask your question now.
Okay, thanks very much. I think that what we have seen so far is that you should stay at home and use the Zoom, then you can hear well and can be heard well. But anyway, so my question, it's a very interesting project that I find interesting in a variety of ways, through a variety of topics I investigated over the years. But my question is, to what extent is this a project about corporations or business corporations? Or is it, in fact, a project about big firms? Let's say, let's look at it on two ends of the spectrum. Let's say that Mark Zuckerberg would have kicked out his roommates at Harvard from the start and wouldn't have turned into an IPO. He could have the entire thing for himself, either as whatever, a sole proprietorship or a sole corporation. And then the question is whether that Zuckerberg, acting as a sole proprietor or a sole shareholder, should be subjected to different duties in society. Obviously, one of the duties is irrelevant for him, that is towards shareholders, because he's the only shareholder. And on the other end of the spectrum, let's say we have the neighborhood grocery, which can be run as a sole proprietorship, as a partnership, or as an incorporated entity. Should any of its duties be altered by the fact that it, let's say for tax purposes, decided to organize itself as a corporate entity? So I'm not sure whether this is, to what extent is this a discussion about corporations or about the biggest enterprises in society?
Yes, thank you. So this is a question I've been struggling with, and also here and elsewhere, benefiting from your work in this area. But I've been struggling with this question a lot. So I think on the one hand, so there's this, I think our normative concerns with corporations gradually increase as the power of corporations increases. So to that extent, I think you cannot treat small companies the same way that you do big companies, right? So that's one reason, for example, in the corporate social audit plan, that we say, let's restrict ourselves to large companies. And we took over the European Union definition of where a small and medium enterprise stops and large companies start, right? But in terms of employees and annual turnover. Doesn't mean, of course, that there can be no domination by smaller companies, right? So to the extent that there is, then you would also impose the same norms on them. But to the extent that, empirically speaking, larger companies are often, or on a larger scale, behaving more problematically, then the attention should be there. Now, should it also, this also, and the part where I really struggle is, should this also be the case if a large company is not incorporated? Well, as I understand it, almost all of them are. Doesn't mean all of them are listed, right? So I'm including closed corporations. Some of them can also be very large, but they still have a capital structure which is separate from the natural persons that are the shareholders. And that is sort of the point where they get a lot of advantage both ways, right? So also the corporation being sheltered from the debts of the shareholders, and not just the other way around. But I'm also biting the bullet. So in the paper on wealth creation without domination, I'm also arguing that we should go in the direction of thinking about a concession theory of markets as a whole, not just a concession theory of corporations. So we should see the whole market sphere as being created for the interest of creating wealth. And that, in a sense, is something that the government, through the enforcement of contract and property laws and then corporate law, organizes. That creates a duty for corporations to compete. So it's not just a freedom to compete, but it's a duty. So you cannot consistently act altruistically or cooperatively, then you're sued by the regulatory agencies which enforce competition law. So the competitive structure is meant to incentivize all the players on the market to create wealth. And that structure is there for a public benefit, also for non-incorporated large entities. But empirically, I mean, maybe you have results on this. I find it's hard to find whether there are a lot of very powerful firms that are not either closed or public corporations.
Thanks.
Asaf, you can ask now.
Okay, so I'm a corporate law professor, and I'm going to follow Ron and Kobe in like making the traditional corporate law moves, right? So there's nothing new here in terms of the kind of the type of the move, but maybe present it a bit differently. So at first I wanted to ask about powerful individuals and why don't we create like a social credit system like the one in China, right? We can do it for individuals as well. And we know that we don't like it as much when we talk about individuals. But then, having heard your response, I'm going to take my second question and then rephrase it. And the second question was, you talk about duties of corporations, right? But the duties are not really those of the corporation, right? There should be the duties of the state or the government to prevent the corporation from dominating other participant in the political, in markets or in the company, right? And in one way, there is a solution to the problem of two big companies, and that's called the Hipster Antitrust movement, and that says, going back to your triangle, even if there are useful economies of scale and other kind of like consumer-based justification for having very large enterprises, maybe for a variety of other reasons, we don't want these entities to grow too big, right? And if you look at the history of the United States, the United States did take measures in the past to dismantle large business entities, and maybe, this is the way we should be thinking about that. And instead of, if what you were genuinely concerned about is entities that become very powerful and do have the power to dominate others, if they have the power to do it, they will do it regardless of what the government tries to do. The best way to do it is make sure that they don't have the power to do it. This is one question. The second question is, I think, whenever we talk about, Colin Meyer, that you try to kind of, criticize in part of your work, and other here, there is one fundamental point that kind of the profit maximizing people say, and that is, the market can sort out easy questions. If we have debates about how to maximize profits, different investors could have different views, but the market ultimately would solve that problem. But even within your solution of the social credit function, once we start trying to maximize other objectives, then we must come up with some sort of a political process to resolve these difficulties, because even within ESG, right, I can think about employees who work in a coal factory, right? And I want to take care of my employees. I want the factory to continue to run. And other people would say, no, the environment is now much more important than the future employment of those poor, uneducated employees. And these are all very valid points, but the political process is kind of the way to sort, those type of issues. And if you just try to recreate the political process in a kind of less painful way through the social audit function, the real problem is kind of the ranking of the priorities. It's not the sanctions, right?
Yes. So the social credit system, you're suggesting I should be in favor of that?
I'm saying, why don't we have the political system resolve the issues and then just create laws that would enforce them instead of creating this system, right?
Yeah. Okay. So maybe first on competition law. So I'm now writing a paper on competition law because, you rightly point out in the triangle, the corporate power triangle, that this is the other triangle, the other way to go, right? And I don't think it should be either or, so we can dismantle certain corporations or at least reduce their size, where their size becomes unmanageable for a certain political community to deal with. But I have also a good colleague, a professor in competition law here, who assures me that this is not the answer, or at least in many cases impossible or difficult or not wise. We could better regulate, right? So competition lawyers can sometimes also be very modest, some of them, about what competition law can give you here. But I agree. Theoretically, so holding them to account and reducing their power analytically are two different strategies of reaching more of a power balance with society. And we should also spend attention on that corner of the field and where that is the most appropriate reaction. Now, the more general point about, well, shouldn't this be on the plate of government and creating laws instead of corporations? So on the one hand, so this is what I would have said 10 years ago. And sometimes when I wake up in the morning, I still think that's the best way. The whole project would intellectually then be superfluous. The problem is that regulation most often regulates activities, right? So let's say making a certain type of food, having a certain type of employee relationship, this or that. And corporate law, as you know, regulates the entity and tries to provide a governance mechanism for the entity. Now, the whole field of corporate social responsibility has come up because of gaps in regulation, arguing that gaps in regulation are sometimes there coincidentally because the government hasn't caught up yet. So it's lagging behind innovations in the market. But sometimes it's really sort of more principled. Sometimes we're talking about issues that you cannot really regulate from the outside very well, because when you're regulating, you're imposing constraints. You're basically telling a corporation cannot do this, you can do that, but that still leaves discretion. And it's within that area of discretion that really interesting questions happen. There are questions of governance on the agenda of the board of the corporation. So you want to have an extra voice on that table. Now, that is sort of the premise on which then the corporate social audit comes in, right? To check these moments of, well, these are incomplete contracts, if you want. So it's the idea that incompleteness will reign whatever you try with regulation. And for those gaps, you need another type of accountability mechanism. But I agree that there's always this trade-off whether we shouldn't do more top-down state regulation instead. Yeah, that's a discussion that will be never ending. But I do see the corporate social audit as a way of ranking then, so as ranking the different types of issues. So such an audit system could give so many points to environmental concerns, so many points to corruption and anti-bribery measures and this and that. So it could give political priorities. I mean, the real problem, I think, is multinationals. So how do you do this in a world in which there's not a neat one-on-one coincidence between states and corporations, so that every corporation is acting in several countries, or the large ones are. So what is the community of citizens that should have a voice over which corporation? That is, of course, a difficult question. I have some ideas about how to make that problem within the context of the audit palpable, but it will remain a challenge. But thanks for the challenges.
Okay, I have a question unless someone else wants to, or you want to phone me after me? After me. Okay, so I have a picky question. It may be just that I was picking on because I agreed with much of your paper. Unfortunately, as we discussed, I like to argue with you. But on pages 18 and 19, you seem to kind of use two different languages for the relationship between resources and when they become capital. And that seemed to be a very important point for you when you kind of build on Jonathan Levy's work. Who's going to be our guest here? I was just making a PR in a couple of months.
Hello to you.
Will do. In any event, so you talk about the process that transforms those resources into profit yielding object of private control. But then sometimes you make a stronger term. You use stronger terms so that it is in order, like in the middle of the page, just 2 lines after footnote 32, you talk about it in terms of something is capitalized in monetary terms in order to accumulate monetary profit. It occurs a few times, this is, I think, the most conspicuous place in which it happens. Now, I think that the former formulation is innocuous and right, but the latter seems to be not always, but sometimes wrong. I mean, with financial assets, that's exactly what we do. But even as you write later on regarding consumers buy something for a purpose, right? It has some monetary value and it can resell it, blah, blah, blah. But often, so I'm not sure that in order to accumulate monetary profit is correct. And in some sense, it seems to me that it is important for you. I wasn't clear why it's important to you to make this much stronger claim, but it seemed to be important for you in order to afterwards criticize the Colin Meyer enterprise. So maybe the answer is that you just don't need that stronger version.
What was the innocuous first version? Where did you find that?
The first version is that another place where it is, it's like on page 19, in the third line of the big paragraph that starts at 19 and shifts to 20, you write that NFCs are valued as, and because they are, means of monetary accumulation. But that's, I think, I mean, you know, we know that there are many things that can be valued as means of monetary accumulation, but not necessarily because they are, or that we turn them into something that can yield profits, but we don't necessarily do it for that purpose or only for that purpose, right? We engage in activities regarding properties that yield profit, oftentimes, and oftentimes it is kind of part of what we think about, but usually kind of put financial asset aside, in which this I think is accurate, but usually with respect to other assets, my residence, right? I think about it as something that has value, and the value is about either profit or, you know, something that is fully monetized, but that's not the reason why most people buy their homes. So the in order to is the stronger formulation here.
Okay, but so if I understand you correctly, the language of in order to accumulate is too strong, and I don't really need that.
I don't know if it seemed to me that somehow I had a sense when I read it that we can have it that you want to make it as strong as that in order to kind of put your own voice in between the Hatchson and the others that you are Boudien and the others that you are intervening. But I don't see why you need it. I'm not sure that you need it. And
but,
if you and I want to and I think it's wrong. I think that many things that we call capital are multi-purposed, and we don't engage with them only for that purpose, or not even necessarily in order to make profit.
But so I think I would have to ask my co-author as well, but what I think what we tried to do here was what Levy is capturing in his definition with the words in expectation of, right? On page 16, but I think our pages are slightly different. So when he says capital is property capitalized, a legal asset assigned a pecuniary value in expectation of its capacity to yield a likely future pecuniary income. Now, I agree with you that from the point of view of consumers, and I think most of your examples were from consumers, right? Consumers value products for their use and exchange value, right? They have to consider the price they're paying when they buy, but then afterwards they value them for their use value in Marxist terms. But the point of view here is the point of view of the firm, the producer. So the idea is that the capitalization decision is often made by the producing side of the market, by firms, and they capitalize in order to or in expectation of a future profit. So they look instrumentally at the non-financial capital and try to bring it into the capital process. And they can also, of course, in their day-to-day business value the same assets non-financially. But as a firm, this qua firm, this is their market assigned job in the system.
Maybe I'm just repeating Ifat's example with the vegan thing. So I'm thinking about the two Turkish scientists that came up with the COVID vaccine, right? So they may have some expectation of profit, and they are certainly happy with whatever Pfizer allowed them to reap before it got its cut. But to say that it is in order to, so the in expectation of means that it's part of what we do here, right? And that's fair. But what I'm saying is that I think that entrepreneurs as well, because they are human beings after all, right, are not just doing things in order to have more cash. That sounds like a caricature of the economic person, right? So the economic person, I think, the kind of not a caricature of the economic person. The economic person is interested, to be sure, with making profit, but she's motivated by something. Not everything is as benevolent of, you know, finding the vaccine or the medicine or solving the problem of how would we make operations more benevolent in capitalism, right? Sure, but they have something that is not kind of reduced to the in order of. And so, and maybe if Jonathan was aimed with the term in expectation of, to say that that's kind of the soul or even the most significant, then I'm just not sure that it's needed.
Yeah. Okay. Well, I think it's good that we say a bit. Yeah. Yes. Thank you. Thank you. So I think we need to say something about the paper. So I think you're right that there are two different points of view here. So the human perspective, if you want, so the motivation of entrepreneurs, why they want to be entrepreneurs and do the things they do. And that might they might need to at least expect profits as a sort of part of their calculations of what they're doing, but not necessarily see them as their ultimate goal, right? So we're talking really about the ultimate goal. I would think they would see them as instrumental goals. So in that sense, they are, let's say, strategic operating purposes, even if they're not the final purpose. So in that sense, we might have to backtrack on the language. Thanks. But so the point of view here really is the systemic one. That in these different types of objective functions, these are the systemic functions that sort of drive the firm as a, let's say, machine in the market, regardless of the non-financial valuings that are also attached to the same production process by the human beings, working in the process.
Roy.
All right, I don't know if I'll be able to make this point completely coherent. It's very closely related to Asaf's point. But to backtrack, I think that definition that John Levy uses is actually very closely related to Veblen's description of capital, and in a way, Veblen is already asking the more basic question of why do we want to have property rights that generate the incentive structure that allows firms to run themselves through capitalization, right? That is, why do we want the pecuniary expectation of return to be the organizing feature for the most important economic actors? Mm-hmm. So by asking that question, we can take a step back and do two things. One is to say, okay, this isn't the anthropological thing about the humans for whom actually status may be much more important than profit, but it is about the structural game. And then the normative question is, for what did we do it? Okay, and then I think you already have an answer. And I think the social audit conception just seems like a little bit of a narrow answer to a bigger question, right? So the big question is, why do we have profit-seeking, or not even profit-seeking firms? Why do we want to allow the concentration of capital in the corporation to be a central actor? And the reason is we want to disperse the decision-making about good things in society. We think that a lot of those decisions could be driven by the idea of profit, because profit is a good proxy for social value. If people want all these things that somebody is selling, some good thing must have been happening. But as your paper starts, it doesn't tell us everything. There are lots of bad things that happen when people want the stuff that people are selling. So profit making is, on the one hand, one indication of social value, but also undermines itself and is problematic. So how do we check it? Now, the social audit could be part of the structure that, on the one hand, says we are actually agnostic about what you do. So you can be the New York Times, right? You can incorporate, you actually need a lot of capital to incorporate, and you don't have to be actually profit motivated, even though you won't break even, so, or the vegan people, or whoever it is. We want that to be part of the same kind of structure of aggregating capital in order to do things that you think are good in society. And we could put you on the same plane as someone who's genuinely just profit seeking. Because we don't want to make all those decisions up front through the political process. But then we also want a political check on the back end. One way we do that is by corporate tax. And you could put everything that's in the social audit model, you could do the entire corporate taxation process this way. We tax everybody at a high rate initially, and we redistribute everything on the basis of some political accountability regarding what was actually good in society. Or we do 50% of what they've taken in, or 20% of what they've taken in, or whatever it is. So it seems like that. I think this is only a little bit of a wider framing of exactly what you were arguing in the social audit, but I didn't see that piece. So I don't know. I'm not sure if there's a coherent question here, but I think it just one way of looking at what might be actually a coherent way of thinking about multi-capitals is thinking that we generate the corporate form in order to be relatively agnostic about what people will actually do, but we don't give up on an after-the-fact accountability or after-the-fact redistribution through the same political process of choosing social goals, which on the upfront end we want to do in a sort of limited way, and up to now we've almost given up on the back end.
Thank you. Please remain seated. I would like to maybe ask for...
One last point. We are almost at the end of our time, so you can answer that and also wrap it up. And we can. Some of us can stay, but I don't want to. So
Okay.
The formal event will end immediately after you
Okay.
do this.
Yeah. I'll stay on for a bit, so there's time to discuss afterwards. At least that I can do. Well, I couldn't come to Israel. Thanks for that question. I think I understand the question. I think I also agree. So I think the double fiduciary duty structure tries to do these both things, right? To recognize the market structure with its incentives and its way of being agnostic about people's purposes in running their businesses, and seeing the profit-making incentive as a way of helping people to, in a process of discovery, as Hayek would put it, to tease out what is socially beneficial, but then also to have this check at the end through the corporate social audit. Now, interestingly, when we started working on this corporate social audit plan, we thought that the financial penalties and premiums that would hang on the evaluations in the audit could be done through lower and higher rates of the corporate tax of corporate taxation, right? So that's exactly your suggestion. We shifted towards a separate corporate social audit fund, sort of parallel to taxation, but organized separately, because we thought we were confronted with criticisms that the corporate tax system, of course, is also influenced by the profits that corporations themselves report. So to the extent that corporations are more successful in tax evasion, they can report lower profits, and the whole system wouldn't work for them, or it wouldn't be applicable to them as you might want from the perspective of the citizenry. So a separate fund in which you cannot choose or manipulate your own profits rate, where you have to pay your premium based on your size, seemed to be a back-end system, as you called it, which is similar to doing the financial incentives through taxation, but the same spirits, right? Just a different financial way of organizing the same spirit of a back-end evaluation of the extent to which corporations have been fulfilling their social purposes. You would still need the political process, however. You would still need the substantive deliberation amongst citizens about what they expect from their corporations in the upcoming 5 years. What are the applicable norms? What do we count as domination, as problematic forms of domination? How do we rate the different issues one against the other? You would still need all of that.
Okay, so thanks Professor Rutgers. And we'll meet next week, and whoever wants to stay, Rutger is willing to stay with us a little bit. I think, Roy, just to clarify to Roy, I think that if I remember correctly, it's social audit, and Rutger, correct me if I'm wrong, it's a jury-like system in which every corporation is ranked according to its own performance, ex post, based on those criteria that are set ex ante. So that's a difference from the tax system. I'm not a fan. I mean, we had arguments about that, Rutger and I. But it's a very different system. It's a system that kind of your fellow citizens look at your performance according to with respect to human rights, with respect to workers' rights, with respect to the environment, with respect to whatever, and say, here you did well, here you did less well, and you're going to be paid according. I don't know if that was.
Yeah, no, I was thinking of a process that might be even less criteria based, that is more political, but it's the same. It's the same.
Okay.
By the way, there is a whole line of literature by.
Can you hear, Rutger? Can you hear Kobe now?
Yes, I can hear it. It's slightly more difficult because you start talking to each other, but it's still okay. Yeah.
I mean, I'm sure you're aware of it, but there is an HBS professor who also, he called it impact auditing, George Safra, that's his name. But he has a whole line of literature exactly about the same. I mean, it's somewhat similar. It's not exactly the same system, but somewhat similar. Impact auditing, they call it.
By whom?
George Safra from Harvard Business School. You might find his work relevant for what you're doing.
Okay, I'm going to check that out. There's quite a bit on auditing and more auditing on social issues. So there are overlaps, definitely. Thanks. I also see something very useful in the chat on lawyers and fiduciary duties, so I'll copy paste that.
Yeah.
Yeah.
If you are interested to continue that conversation specifically, I'll be happy to send you like the relevant links. But the idea is basically that similar to what you presented, lawyers are both fiduciary to their clients and to the whole justice system. And then comes the question of how do you balance these between them, and sort of, there is some critical writing about it, so people say it's impossible. You can't have two fiduciary duties. You must sort of choose and then to define the duty towards the state in a different way. So
I was very much influenced by this book by Fox Decent. Have you heard that name? So he really sort of tries to defend the idea of multi-fiduciary duties against those who say a fiduciary duty, by definition, can only be towards one party. Otherwise, it's not a fiduciary duty. But he tries to reinterpret the social contract as, okay, a government must now do, has a fiduciary duty towards citizens as beneficiaries. They might have conflicting interests, and balancing them is then the fiduciary duty.
I think your problem is that even Fox, he writes a lot about public fiduciaries, so the state is a fiduciary, and here you are somewhere in the middle, you're closest to the private law writing about fiduciary law, because, and I think corporate law is somewhere in the middle between, a classic trustee, which is, private law extremely, and then you have the corporation that it's not a public entity, but it's also not exactly a private entity, so you're somewhere in the middle.
Yeah.
So I think lawyers is a good example because they are, on one hand, it's clear that they are supposed to work for the benefits of their clients, and that's the main purpose.
Yeah.
But then on the other hand, they also have some kind of general duty, so they can't lie, for example, for the client, right?
Yeah.
So even if it's for the best interest of the client, they still can't lie because they have a certain duty towards the state and towards justice and towards.
But then I think that actually.
No, I won't do that.
No.
We won't do that. I think that it actually kind of flashes out some of the difficulties that we discussed earlier, because with lawyers, these are basically injunctions. There are things that lawyers must not do, So it's in your language, it will be, I think, a constrained thing, right? So one fiduciary duty will function as a constraint, and the other as a right, and that is how they can coexist.
Yeah. So that is, and that is really sort of what I'm still struggling with. So to what extent should I uphold this constraint purpose distinction? Also because certain forms of regulation by the state today are not just command and control regulation, like do this, do that, like very clear prohibitions and allowances. No, it's often also now more principle-based, right? So a regulator is going to say to an organization, this should be your rough goal, and then we're going to have a deliberation about what you can and cannot do in fulfilling that goal, but it becomes less of a side constraint. So the whole terminology of side constraints also becomes misleading when regulation becomes more open-ended.
Right. In any event, she's the expert on fiduciary law here.
Okay, I can't see you through the computer. I see you from upside, from the big camera in a room.
Wait.
So I see you looking at the screen, but I see you from the top camera.
You're from Rotterdam? Utrecht University. So you don't happen to live in Amsterdam?
I grew up in Amsterdam, but I left when I was 18. So
the reason I'm asking is because I'm going to be in Amsterdam next month. So I thought.
Ah, really? Well, I mean, Amsterdam is only 30 kilometers away, so maybe we can meet. I missed your name. Sorry, what was your name? Sorry?
I'm the only one still on the computer. Like my computer is open, so you can see the spelling.
It's Ifat Naftali Ben Zion.
Ah, yes.
Yeah, the very. But I'll send you an email.
Yeah.
With more references on lawyers and fiduciary if it's.
You're going to visit people in the law faculty in Amsterdam?
I'm going to present in the center there, in the private law center.
Ah, yeah, I presented there last a year ago as well. Very nice people. Maria Bartel, do you know her?
Yeah. Exactly.
Yeah.
But it's a private law project. It's not on corporate law. So.
It's not on corporate law. Yeah. Well, I think fiduciary relations are very interesting. So I'm now reading this book on the philosophy of fiduciary duties, but I think Hanok has an article in there as well.
One of Paul Miller's many books.
Yes, but I mean, so there are now more and more people but especially, I think still from the law side mainly, who have interpreted political and public relations as fiduciary relations.
Yeah, that's Evan Fox and Evan Fox has been here as well, and Evan Friedel and Ethan Lieb mostly.
Yeah, but political philosophers have not really taken this up yet. So I'm trying to do that, to say, hey, here's something interesting for political theory happening mainly by lawyers, but really important.
Notwithstanding the fact that it's done by lawyers, you want to say?
Well, I mean, philosophers often think, I don't want to read legal text because then it's getting hopelessly complicated. But I think in this case, this is unjustified, because what these lawyers have written is crystal clear for philosophers as well. It's a different technical expertise, of course, in the end.
Super. So, Raga, you will need to get in touch, to keep in touch, and you definitely should come. We'll see what happens with COVID. I mean, hopefully here it subsides. We hear that in Europe and elsewhere it's becoming now, it's becoming again.
Yeah, it's incredible. We have 15% who is non-vaccinated, but still this causes a rise of the cases now in the hospitals. So I think we are now where you were like 3 months ago or so, with a new wave, a smaller one, but still not good.
Wait for another month, please.
Yeah. No, I won't come before spring. Maybe in spring or in the next fall. Let's see. But I would love to come over. And a great bunch of people you have there. I was really intimidated that Ron Harris was there, because he's really a giant in the corporate literature as well. So I was like,
I mean, just tell me when. I mean, we'll see. And Noami may know as well when it's clear on both ends, so you don't need to get quarantined either, you know, on your way here or on your way back. And we'll just arrange something. That will be really lovely.
Yeah, absolutely. I would love that. And well, this was a great discussion today. So really useful. I've made notes of everything. And do you have a recording? Because I think it was recorded, right?
Yeah, it was recorded.
Can you send me a copy of it?
It was not supposed to be like that in terms of Zoom wise. It's like it's really unfortunate. I'm really sorry.
No, it's okay, but yeah, these things happen. So hybrid is most difficult, right? So everybody in the room or everybody at home. But hybrid is most difficult.
Ron was correct about that as well.
Yeah. But if Noah could send me a copy of the Zoom registration, that would be great. Then I can look back certain moments where, yeah. Your corporate lawyer was also very tough. Yes.
Stuff is tough. I mean, both Kobe, who is the first, and then and Ron and Asaf, all three of them teach corporate law here.
Who was the first one? So Ron and Asaf and?
Before Asaf, it was Kobe Castiel.
Okay.
Kobe is a former student of Lucian Bebchuk. He's also a co-author of Lucian in some projects, and Asaf as well, co-author and a former student of Lucian. And Ron is not, obviously.
Okay. So when you emailed me 2 weeks ago that you wanted to have non-lawyers also looking at the corporation, that's why you brought me in. This was to talk to them, right? Or
you know, it's like the others, the Safra fellows were, I think, too intimidated actually by the corporate stuff, right? I think they were. Yes. No nods. Like we talk about property, we talk about contract, we talk about the market, but the corporate stuff is like hardcore, or at least it sounds hardcore to the non-lawyers.
Okay.
And actually to the lawyers of the group as well, because they don't do corporate law.
Yeah, although general discussions about business ethics, business in society, most people would not be afraid of, right?
Yeah. And one of our fellows, who's a political philosopher, is actually turning to, he didn't start with that, but he's actually turning to business ethics. So hopefully it was, we'll see. Hopefully it was, I thought it was very interesting to everyone. And I think the paper is really interesting. As I told you, I love arguing with you, as you know, and I was hoping to pick up a fight, and it was difficult for me this time.
We'll return to the fight about the corporate social audit at some point.
We will. And you should be in touch with Colin, I think, with Colin Meyer.
Yes, I should. Yeah, you're absolutely right. I've postponed this. I first wanted to learn more over the last 2 years, but I think I'm now at the point where I should dare to approach it. Yeah.
Okay. Keep in touch, and
So,
bye-bye.
and I will write to you as well about some more maybe references if you need them. Okay?
Thanks. I also have a paper about the duty of professionals, where I do touch a little bit on sort of fiduciary duties of professionals, which may be of interest, also relating to the law case. But yeah, please write me an email. And thanks for your questions.
Sure.
Thank you.
Bye. Good night.
Bye,
Thanks so
thank
much.
you.
Thanks.
Thank you, Professor. I'm sorry about all the trouble.
We also had these troubles in our main presenting room, so I recognize it. It's the challenge of this day and age, the hybrid meeting.
I hope next time we'll be here.
Yeah. Okay. Looking forward to that. Bye-bye.